that's coming for everybody, doesn't matter what industry you're in, is the Payday Super, which starts from the 1st of July. So what that means is that every time you pay your employee, if it's weekly, fortnightly, monthly, you have 7 days to get that super payment, the 12%, into the super fund, or you're going to get a penalty. The penalties for the first 12 months aren't as severe as I thought they might have been. There'll be an interest charge added, and there's currently saying that'll be at 10%. There'll be an administrative penalty, which will be $20 per employee per quarter. And there'll also be, if you're a director, you can receive a penalty, director's penalty notice. So the old-fashioned clearinghouse that you used to use through the ATO if you were a small business shuts down on the 1st of July. So you need to ensure either your super fund can take your payments directly, or you find a clearinghouse that can do it for you. Will depend on which state you're in and what your super fund does. But you have to allow for complications in the system, particularly starting off, that you do get them in on time. And as often happens too, when you've got new employees, etc., sometimes the first payment will fall back because you've missed a UAI number or something like that. Just whilst we're on new employees, they're actually going to give you 20 days on the first payment. So just say I was starting with you on the 1st of July, and I'm a little bit slack as some of the employees are getting into super details, you will actually have 20 days to submit the very first payment, then you fall back to 7 days. The same as if an employee decides to change super funds for whatever reason, there's always a bit of a hiccup with those going across. They're going to allow 20 days to do that as well. So be warned. So that's coming on the 1st of July. Most software programs now, I know Maya Blight at the moment, the one I use, when you're doing your payroll run, it now has a section for you there to tick and click and get your super paid in within those 7 days. So that's something that's pretty handy to know. It's going to be run by the ATO, so we'll need to be sure that we make sure that you do get those things paid on time. So the consequences, of course, are that you're still going to have to pay the super. You're going to have interest added to it, which is currently going to be 10%. That will change, I'll guarantee you that. The administrative penalty of $20 per person per quarter. And if you're a company director, that becomes a director penalty notice towards you. Now, the question I get asked the most is, do I have to pay contractors and subcontractors superannuation? Well, it depends on the circumstances, and I've had many a discussion on this before, but it's worthwhile going over again. So the ATO says that if you tell a person when to work, where to work, how to work, and provide the equipment, irrespective of whether they've got an ABN or not, and they call themselves a contractor or subcontractor, they are not, as far as the ATO is concerned. They are an employee, and you will have to still pay the super guarantee. The easiest way to think about this is if you're paying them hourly, or they have no control over passing the job on to somebody else, and you are providing equipment, they're definitely an employee, and you'll have to pay the 12%. So just make sure that you have that one covered. There's been a few matters before the Fair Work Commission at the moment, and through the ATO, where properties are getting fined for not paying super. You actually report unpaid super to the ATO. There's a separate section there in the ATO that handles that, and there's plenty of penalty notices going out because people thought they were didn't have to pay contractors, but that's not exactly right. If they're an employee, the only time I consider somebody to be a contractor is you ask me to plough up some paddocks for you or to harvest some cotton for you, and I give you a quote for 5 days at $1,000 a day. That's a true contractor. But if you're telling me when to come in, when to start, what days to do it, so really I have no control over what I'm doing. You have control. I'm definitely an employee. So what do we pay superannuation on? So you don't pay the superannuation on all hours worked. You pay it on the first 38 hours per week, which is classed as ordinary hours. You also pay on annual leave, you pay on personal/sick leave, and you pay, if you do pay a performance bonus, that is included as well in superannuation. So it's just not the 38 hours, Sunday ordinary hours, if it's under the award, annual leave, personal sick leave, and performance bonuses. What you don't have to pay super on is redundancies. In lieu of notice, now in lieu of notice, that's if you're terminating the employee straight away. So in other words, you're not going to get them to work out to 2, 3, 4, 5 weeks, or you don't want them to work to 2, 3, 4, 5 weeks, you would pay super on that. But if you're paying half pay in lieu and half they've been still working, well, you'll have to pay the half they work. Some employers require their employees, if they give, say, 4 weeks notice, to work the first 2, because they halfway through a job, or they've got the secret herbs and recipes to the fertilizer mix or something that you probably haven't written down, and you need them for their experience for that time. Even though they've resigned, you can get them to work those 1, 2, 3, 4 weeks if you want to, but anything that you don't want them to work within their qualifications, they need to be paid out as payment in lieu. You also don't have to pay superannuation on ex gratia payments, so that normally falls into my domain. If you've got a troublesome employee that we haven't quite reached the Fair Work Commission yet, or the Industrial Relations Commission, or somewhere else, and we decide to do a deal, sign them up to a deed of agreement, deed of release, deed of settlement, those payments don't attract superannuation, and that goes without saying to any settlement as well. So if you do unfortunately end up in the Fair Work Commission or some jurisdiction and you have a settlement, there's no requirement to pay superannuation on settlements. So we don't have to do that one as well. So that's pretty basically the new rules. Just remember, 1st of July, I can't even tell you what day that is, but it's not far away. If you've got a software program and it's not allowing you to set up for same-day super, you best get onto them to get it sorted. The other issue I'm also seeing with superannuation is, depending on what box you tick in your software program, and there's so many out there, and I'm certainly no expert on all those programs, just check your box is ticked for ordinary hours worked, and then if you do have a bonus system or something like that, performance bonus, that box is ticked as well. Otherwise, as I see time and time again, people are paying superannuation on 60, 70, 80, 100 hours, and it's very, very hard to claim that back. Most super funds won't refund it. So basically, I had a situation in Toowoomba probably this time last year, maybe a little bit earlier. All we could do there for them is draw a line in the sand, tell the employees that there'd been an administrative error. You're now only going to get paid on your 38 hours plus bonus. They were on a bonus system. So basically, guys, you've been given a free kick for that, however long it was. But actually, it was this time last year, because I remember we held off to the 1st of July and we kicked it off under a new year. So the employee's got no comeback to you. You've actually paid over and above what you're meant to pay, but at the end of the day, you're paying more than you necessarily have to. So why pay more than you need to? But I'm always available to be able to sort that out. If you have an issue, just let me know about that.
Wayne, got a question coming in on the chat. Do you have to pay super on time in lieu if it's been taken in lieu of a payment? So I think that's what we've got here. So if let's just say I've worked 3 extra days and I choose to take those 3 days off, do I need to pay super on that?
Yes, because you're paying for in lieu of work that's been performed. So yes, yes, you would.
And also, I think you covered it, but if I pay a person a bonus for the year, that's subject to super or not subject to super?
Super, if it's part of earning the income, yes, correct. Yep. That forms part of the salary package. So quite often too, it'll depend on how your employment contracts are done, but some people have a discretionary bonus, but that's the bonus they've made by working the hours to get you to where you are. So that would be included, correct? Yeah. Any more questions on super before we move on? Is it pretty clear to everybody?
Well, nothing coming in at the moment, Wayne.
Okay.
Well,
So
we might move on, Wayne. Yep.
Yep. Happy
Oh,
to
hang
move
on.
on. Okay.
Yeah. Do we only pay on a 38-hour week? So I think the answer to that
Correct.
is yes.
Yeah.
Yep.
If your employees are, yeah. So that's for full-time employees. Obviously, for part-time employees, they're only doing 30 hours or 32 or whatever. They're pro rata. So yes, you have to pay that as well. So I just want to quickly go back over subcontractors. If there's one thing I get from the pastoral industry all the time is what's a contract and a subcontract. I touched on it, but I just want to reiterate, irrespective of whether they've got an ABN or unless they invoice you for the work, they're not a true contractor, particularly if you're supplying the equipment and telling them when to work and what time to work. It's very important. The ATO's got a little division now, as has the Fair Work Ombudsman. They've just been given around about $28 million to start tapping on some more doors. I know they've been pretty prolific up in Gundawindi, as have the Federal Police for visa workers. I've had a client up there that had a knock on the door about 8 p.m. one night wanting to look at their books and records in relation to some student visas. So just because sometimes you're in some of these far-flung little country towns, the tentacles are starting to reach out. And of course, the ATO data matches with everybody else, so you just need to be careful that what you send to them is a true record. Otherwise, you'll get a tap on the door.
I just had another question pop into the chat.
Sure.
If you have an individual flexibility agreement and the agreed hours are 50 hours per week, do you pay super on 50 or 38?
If that's classed as their ordinary hours, yes, you do. So ordinary hours. Yep. And I'm actually going to come. I might as well do IFA nows while I'm there. Thank you for whoever brought that up. For those that are not aware, an IFA allows you, and it's an individual flexibility arrangement, so it's individual between one person and the next person. It allows you to change 5 things out of the pastoral award. That would be wages, penalty rates, allowances, overtime, and the 17.5% annual leave loading. Doesn't mean you don't have to pay them. There's just a way around doing flexibility so that particularly your payroll clerks, those that do the pay, they just like to be able to hit the button with a flat rate. First of July will be the new wage increase will come through if there's going to be an increase. The unions are pushing for 10 to 12%. Of course, the employers are pushing for 0%. I'm hearing rumours of around about 3.75 to 4%. The budget didn't help us, so I read an article yesterday, I think it was, from the Fair Work Commission saying that they've got to go back and review the latest CPI figures on that to come up with a fair decision. So there's four members of the commission and a layperson that are, as we speak, working out what the new pay rates will be. That happens on the 1st of July, or the first full pay period in July. They're a little bit more forgiving than the ATO that wants everything done on the 1st of July. So if it's the middle of a week, you've got to do pro rata. With employment, you just do it from the first full pay period. So if your next pay run after your last pay run's not to the 5th or 6th of July, that's when you start the new pay run. That'll get announced in the next 2 weeks. And then when you go to your Fair Work Ombudsman's minimum pay guides, you'll see the big words draft across them as a waterproof, just so or a watermark, so that you don't start paying those figures till the following year, and then you kick in, and that's when you pay them. Just a reminder that it applies to all grades, all classifications. So don't make the mistake. Sometimes the media puts it out that now the Australian minimum rate is $24.95, for example. That's not necessarily an under your award. That's basically for people that are award free. There are some people out there in the workforce that don't have an award, they don't fall under. Accountants are one, solicitors are another, IR people are another that don't fall under an award. You're not allowed to stick them under the miscellaneous award where most people seem to run to when they can't find an award. That doesn't fit anymore. So don't be mistaken for that. And a reminder too that
Wayne, just on that,
yep.
I've got a farmhand. I'm paying them well above the pastoral award, whatever that is.
Yes.
Are they still subject to the award? And in that case, I would need that individual flexibility agreement, or what sort of paperwork or connection do I need to have if I'm paying above the award and sort of thinking to myself, well, I'm doing that so the award doesn't apply?
No, the award will always apply. It's just the pay rate. So all your obligation is to pay the minimum rate. If whatever you pay over and above is your prerogative, and I've got clients at the moment saying to me they can't get people for under $55, $60 an hour as a casual, when the award clearly says for a farmhand level 1, $30.35. So if that's what the market's demanding and that's what you have to pay, that's what you have to pay. However, when the wage increase comes in, and just say it comes in at my prediction of 4%, and you're currently paying 5% or 6% or 7%, you don't need to increase their wage. And if they come to you, just say, no, you're already being paid above the minimum rate. So my suggestion to every farmer, every employer is you just go to the Fair Work Ombudsman's minimum pay guide, look up the classification, see what they're currently being paid, remembering, particularly in your industry where you do excessive hours, that you need to factor in the fact that they're working 50, 60 hours. So you've got to put the overtime rates in, etc. Are you working on public holidays? Remembering now too, there's a new law happened as of last year. You have to invite your employees to work a public holiday. You just can't just assume they're going to work. There's a few people got caught out at the Easter one. A few things heading towards the Fair Work Commission now, where people failed to invite the employee. Look, most employers will work it. You will have discussed it, but there's some, normally the partner that doesn't want the employee to work on the public holiday. They'd rather go have a holiday or do whatever they do. If you don't invite them to work, then again, you're stuck. So you need to factor those in as well. Remembering too, depending on your operation, if you can afford to, you can actually swap a public holiday out. So if you need somebody to work a Good Friday and they're happy to have the following Friday off or in a month's time, no issue with that. You just swap a day for a day. You'd still pay them, but you can swap the day out. But very important, particularly if you're in Queensland, unions seem to be a little bit more active up in Queensland than they are in New South Wales. They're tapping on people's doors. Oh, and in South Australia, which is where this one I'm doing has come from. The unions are very active. My member didn't get invited to work. Therefore we're going to put you before the commission, which it's a lot of wasted time and that. So if you can circumvent that, you can circumvent that.
Yeah. A couple of other.
So does that answer that question, Michael? Yeah. So the wage really doesn't have anything to do with the award, other than that is part of the award, if that makes sense.
Yep. No, that's good. A couple of other ones. This goes back to that contractor and super issue. Do we pay contractors into their super or pay directly to them?
Into their, I would have thought, I'm not an accountant, I would have thought into their super. That way you've met your liability of paying it into their super fund, because once you give it to them, what real proof do you have other than your bank statement to say that it went in there? So, yeah.
Yep. And another one, how do you practically manage reasonable additional hours during peak periods, and what's the defensible approach to using time off in lieu?
So, no matter what I tell you today and what I believe in, we get trumped by work health and safety. They beat us. Safe Work New South Wales, Safe Work South Australia, whatever. They consider reasonable hours to be hours that are manageable by both the employee and the employer. So I know the mines down the Hunter Valley now, they've got special dispensation. If you live more than an hour outside of the mine, they cannot be discriminated against for not giving you a job, because they expect you to work 12, 14 hours a day. It's part of their enterprise agreement. And there's been far too many people run into a tree, run into a car, hurt themselves, etc., etc. So reasonable, it means reasonable for both parties. The same as if I'm the coach of my grandson's under 14 Moonby football team and they train of a Thursday. Through my flexibility rights, through my guardianship rights, through the reasonableness of overtime, it will be unreasonable for you to expect me to work that Thursday afternoon when I coach the footy team from 4 p.m. till 6 p.m. Basically, horses for courses. Yes, there are peak times and it is recognised, but you certainly wouldn't be working anybody more than 14 hours a day. You know, I did read a decision in the commission in the last couple of months where basically the commissioner told that was the respondent, yeah, so the employer that will hire more staff then. So easy to show that they don't live in the real world where there's not necessarily the pond of people to do it, but for reasonableness you need to. It's a two-way street. Reasonable that you need it to get your crops off or your crops in, or whatever it is you're doing, but also the work health and safety aspect. A little statistic that I just wrote down too when I was preparing for today came through that 1 in every 5 workers' compensation claims in New South Wales now is a psychosocial hazard claim. Now, that's the latest buzzword. The government tried to get it knocked on the head, but the lawyers cried because they weren't going to make any money out of it. So psychosocial hazard, I won't bore you with it all, but basically if you're giving your employee too much work, not enough work, the way you speak to them, etc., they'll go running off. The next thing you'll have a workers' comp claim and they'll claim psychosocial hazard. When you get off here today, if you've got some time up your sleeve, just Google it. I think there's 27 points that you can claim a psychosocial hazard on. I know a lady in here that's going to hire another 2 staff. She can't keep up with it here in Tamworth. Just doing psychosocial over and above every other workers' comp claim that comes across her desk. So just be careful if you start hearing your employees, and particularly backpackers. I've said this before, was proven to me a week ago, so I'll say it again. Somebody out there is educating backpackers into industrial relations and contract law pretty close to the level that I deal with. They've really got to focus at the moment on underpayment of wages, which I'll remind you now is a jailable offence. So it's now a criminal offence to underpay somebody's wages, and if it can be proven, nobody's been prosecuted yet, but it'll only be a matter of time. If it can be proven that you deliberately underpaid somebody, you can now go to jail for that. That came in November last year, so you just need to be careful about that.
And Wayne, just going back to that earlier question and just rereading again, I think what the question might be getting at, let's just say it's harvest, my normal working hours are 38 hours a week, but we're doing 80 hours a week over harvest. Do I have to pay that employee overtime on that, or can I say, well, that's all going to be written off as time off in lieu in the future?
If so long as the employee is willing to do that, and my easiest suggestion that is that you just write up just a simple couple of paragraph agreement saying that the employee wasn't coerced into this and they're happy to do that. With time in lieu under your award, it must be actioned within the first 6 months of it occurring. And this is a pretty good example. So here we are, the 27th of May. So let's say that this is the season when you're going to be busy, and some of this time in lieu carries over into the new financial year, so a new pay rate. Luckily in your award, and it's one of the few awards where they allow it, so I decided to throw my hands in the air in, say, September, October, and I've got time in lieu owing. You only have to pay me that because you've got to pay me out. You only have to pay it at the rate on the day it was incurred. So most awards say if you went from $35 to $40 an hour, and I up and leave in September, you'd pay the $40 an hour. Under the pastoral award, no, you can actually go back to the date that it was incurred. So there's a little bit of a saving there. So yeah, no issue with that. The Fair Work Commission's happy so long as you can't be proven that you were trying to do over the employee. You had their best interests at heart. You're not going to get into trouble.
Very good. No, just in the chat there, apparently there's a template for time off in lieu agreement within the pastoral award, so people can
Yes.
find that there.
Yep.
And also, Wayne, you touched on fatigue, and it's just worth noting that in New South Wales, the new fatigue management code will come in on the 1st of July, and we'll actually have that as the topic for one of the upcoming webinars.
Correct. One of the other things you can do in your award too, if you want to try and avoid some overtime, is the 152 hours over 4 weeks. But a lot of people are getting confused with that. So you can do that, but that's only based on ordinary hours. So Sundays, for example, Sundays you still have to pay. If you want to put it as part of your 152 hours, it can be any day of the week, but you must pay the Sunday rate, because they class that as a non-sociable day. That's a day where in the old days we used to spend with our family doing whatever we did. So the unsociable hours, so there's a 200% penalty there. I'm not a great fan of it. I did some sums for a client of mine in Moree 3 weeks ago. We did the ordinary, just Monday to Sunday, throw in the overtime. Don't worry about days off, throw in the overtime. Then we did the 152 hours over the 4 weeks on the pattern he was doing, and it worked out over the 4 weeks he was paying $338, and I can't remember the cents more. So he was quite happy with that exercise, just to go back to doing the weekly pays. So it all depends on your operation. And my disclaimer to everybody is, I don't know your operations. Some are big, some are mum and dad operations. So just do the sums to see if it works for you. But remember, it's only ordinary hours. So ordinary hours in the pastoral awards from 6 a.m. till 6 a.m. till 8 p.m. So if you go outside those hours, unless the employee agrees to go outside them with you, they're not classed as ordinary hours. So you need to be careful about that. IFAs, as I said, they're good. They do work. Particularly pay clerks, they like those because it turns into a flat rate. You've just got to make sure you've accounted for everything and you've passed the better off overall test. So they cannot be any less than what the award says. And the other thing I see in these two, when people try or do IFAs, if you've got a house and you're charging them rent, or you're not charging them rent, but you believe the house is worth, say, $100 a week, you cannot deduct that from the hourly rate. That's known as a non-monetary benefit. So you're going to come to work for me, or you're going to come to work for Michael. I don't offer the accommodation. Michael offers the accommodation. We both pay $300 a week. 99% of people go to Michael because they're getting a house. So most times it's on the property, and secondly, they're not paying rent. Michael would normally throw in electricity or something as well, internet these days. That's a non-monetary benefit. Would you come to me where you've got to go into town, so there's a 10, 15, 20-minute, half-hour drive to work every day? No, you'd pick Michael. But just because Michael's affording that to me doesn't mean that you can deduct anything from their wages. The only thing you're allowed to by law to deduct from wages, surprise, surprise, is taxation. Even in the old days when the social clubs used to be around, you used to have to get a letter from the employer to say that you're authorised to deduct their money from that. So just be careful that you don't start incorporating rent into those. Even if your neighbour's doing it, even if the employee says, oh, this is what we did on another farm, don't chance it. As I said, there's a lot of data matching now. Every government department talks to another government department, and you'll soon get caught out. So you just need to be careful there. Yeah, in New South Wales, 1 in 5 workers' comps now is a psychosocial hazard claim. So my experience has been, in the couple that I've come across, is that QBE, Gallagher Bassett, which are two of the insurance companies that I deal with, have knocked them back provisionally. That it's really only if a lawyer or somebody sort of takes over and pushes the envelope a little bit more that they may reconsider it. But it's a bit like a bad back. Did it happen? Didn't it happen? There's a lot to go through. It's just one of these things that snuck into the workplace, seems to be flavour of the month, and it can cost you a lot of money as an employer. So you just need to Make sure you dot all your I's, cross your T's. If you've got a troublesome employee, make sure you follow procedural fairness. I've said it before, no such thing as 3 written warnings. You don't have to give 3 written warnings. They don't expect you to put up with somebody's issues 3 times. All you have to do is make sure that you follow procedural fairness. So investigate the issue, give them your expectations, see that they can match the expectations, do it in a timely manner. So if it's something simple that can be fixed in a day or 3, give them a week. If it's something that's going to take 3 weeks or 4 to fix, I normally give them 5, 6 weeks. If they haven't done anything after that, just issue them a show cause letter saying, why haven't you basically done what we've asked? If you're not, if you don't do that, we'll terminate you. I do suggest you make a quick phone call to myself or somebody that you trust with IR law to just check you're on the right track. Only yesterday I was in the Fair Work Commission for one of your members. They've done everything right, even rang me. I gave them the information. They followed it to the letter. They've done everything. We still ended up in the Fair Work Commission. We couldn't settle in conciliation. We had just over 4 hours yesterday in the hearing. I think we've won, but the commission's now reserved the decision for 2 weeks. So we're now got my client, one of your members, has now got to wait another 2 weeks to find out if we have to go yet another step or whether it's just going to get thrown out. It was something ridiculous that the employee believes he has a right to. My job was to prove that it wasn't. They followed the letter of the law, but you can still end up in the Fair Work Commission. So if you're going to end up in the Fair Work Commission, my suggestion is let's get all the I's dotted, the T's crossed, do the best we can, and then we're in the lap of the gods then. But so long as you show that you follow procedural fairness, you really can't go wrong.
Wayne, a couple of other questions in the chat. One goes back to the accommodation issue. Can you offset the employee's accommodation for overtime hours?
No.
Nope. And somewhat similar, can I deduct electricity use from wages if I have a written agreement with the employee?
Most definitely you can. And you can do the same with the rent too if you want to, but you must have a written agreement. Just whilst we're talking about accommodation too, this pops up all the time. So I'm renting your place. From time to time, we won't get along or an incident happens, I turn into be a baddie. How are you going to get that person out of your accommodation simply because you want to replace me with another person, or you just want them off the premises? My strongest suggestion is you go and speak to your friendly real estate agent. Get them to come out for 2 reasons. One, just to give you an appraisal. They can't value, they can only appraise, but appraisal on what the rental value is on your place. But more importantly, get them to set up a residential tenancy agreement, so that at the end of the day, your employee knows when you start them that, should we want to part ways, you've got 2 weeks to get out, or you've got 3 weeks to get out, or whatever state you're living in, whatever the rules are around there. It just saves, again, ending up in a tribunal or the Fair Work Commission because they're unfairly treated. And as I said, I've even seen one with psychosocial hazards, so you just need to be very careful there. So just protect yourselves, have one of those in place. So even if you have one of those in place, and Michael's on my property, but he's going in 2 weeks' time, I issue him a letter that states that, Michael, whilst ever you remain on my property, you can only exit the property from your front door to the main road by the straightest possible route possible. They're not allowed into farm sheds or to drive around the property, with the exception if you've got a property that's got a tip on it or a dump point to dump rubbish, because trust me, there'll be some rubbish. You permit them to do that. The reason you're doing that is that they're not really covered by workers' comp. They're no longer your employee, and depends how educated people are, that may give you an extra claim against you. So just cover yourselves. They can only travel from the front door to the main road. They're not allowed in sheds. They're not allowed to drive around the property. Give them the 1 or 2 times if you do have a rubbish tip on your place where they can tip the rubbish. Other than that, they basically can find the quarters or don't come onto the property during the day.
So Wayne, just for clarity on that. So if I just assume that I'm offering this accommodation while ever you're my employee and you're no longer my employee, that does not necessarily mean that they have to vacate the house. Like, it's almost two separate issues here, is it?
It really is. Whilst they're not your employee, again, you know, we've gone woke in society. So even the Fair Work Commission would say, so remembering for an unfair dismissal too, or even if you dismiss somebody, the Commission is looking for, you know, the dismissal, whether it was unjust, unreasonable, or unfair, so or harsh. So the Commission would rule that, you know, you got rid of Wayne today and you're booting him out that afternoon, you know, because obviously you want to bring the next bloke in as soon as you can get them. I think you'd find, well, one of your members did run foul of that, and luckily they had they wanted to get him outside earlier of the agreement, because had somebody wanting to come in that had wife and children. So it's not always necessarily the young fella, it's always there's a partner, or even for ladies, they've got a husband or something live there as well. So you just got to be careful that you know, don't run foul of those jurisdictions as well. So that's my recommendation. If you don't have a friendly real estate agent, or you prefer not to do that, maybe you need to get something put into your agreement that says that, you know, we're providing you the accommodation with this and that, and obviously you're going to put in there too that you reserve the right to go and inspect that property from time to time. I know of one of your members who somebody was vacating or something, and they'd ripped a wardrobe or a linen press or something down, left a gaping hole in the floor. That means you've got to go back through a civil court. That's not something in my jurisdiction, but you'd have to go through the civil court to get compensation for that. So if you tie yourself up with one of these agreements, I think you're far better off. And I just see it more and more now that you know, people just digging their heels in, and you know, we get to day 13 and no, I'm not leaving. I'm entitled to be here to day 14 till midnight. So things I hope that never happen, but they're things that I come across all the time. So you just need to be careful about that.
It's got something else pop in the chat. I've written accommodation policy which says accommodation is provided as part of employment. If employment ends, then they have 7 days to vacate the accommodation. Is that okay?
Yep, if that's an agreement and you've got a signature on it, that's perfect. That's ideal. That's what you would have. Yeah, correct. Yeah.
Very good.
My job's just to avoid you ending up in situations where it's costing you money. There's a saying in the Fair Work Commission, even when you win, you lose, because the Fair Work Commission is a self-cost jurisdiction. So unless we can prove that a claim was frivolous and vexatious, and even then, 99% of the time, the Commission won't award costs against the other person. So it's cost you the time off your business to provide me or your lawyer or whoever with the information to put the claim in. The Commission requires you to be there. One of you must be there, somebody with a full authority to settle. That can't be me. So you time out of your business. And even at conciliation, I've only ever done one conciliation in the near on 10 years I've been doing this now, where money didn't exchange hands just to make it go away. So if you can avoid all these sort of things, just be very careful. Also in the Fair Work Act, when you're talking to people, particularly if it's a disciplinary matter, there is no requirement to afford them a support person. I strongly recommend that you do. Just once again, that shows that you've given the employee the opportunity to put their case forward without you basically being the overbearing person. The support person can't advocate for them. They're basically there just to sit there and ask, ask for an adjournment, or ask, can you pass the box of tissues or a hanky if they become emotional. They don't have to remain mute. The Fair Work Act says they don't have to remain mute. They can ask questions, but they can only ask them through the employee. They can't advocate on the employee's behalf, and they can't disrupt the meeting. If you ever have one of those, just can the meeting. tell them to go and find somebody else to bring in. You cannot, contrary to popular belief, you cannot stop a fellow employee being a support person unless they're part of the investigation or parties of the situation. So there's a few companies out there, I'm seeing letters coming to me of late saying we've expelled any employee or previous employee from attending. No, that's not what I'd be doing. That's not how the Act works. So now, Michael, I'm just trying to remember, did I go through the new farmhand levels now for, so they've thrown in farmhand level 2 now. So somebody that's a new employee with less than 6 months experience is employed as a farmhand level 1, but now they've thrown in farmhand level 2. So from months 7 to 12, they become a farmhand level 2, and they can stay there if that's as good as they're going to get. That's as good as they're going to get. If they're showing signs of, you can actually basically tell them at the beginning of the week to go here, there, and do this and that. And there's only minimal supervision. You then move into a farmhand level 3. That's after 12 months. And then they stay at farmhand level 3 forever and a day, unless they're the senior station hand, which basically is giving direction to other employees when they become a farmhand level 5. All the other levels, 6, 7, 8, 9, only deal with dairy farms and feedlots. So if you don't have a feedlot or a dairy farm, you don't need to be involved in any of those. So we used to just say 1, 3, and 5. Now it's 1, 2, 3, and 5.
So if someone thinks they should be a 3 and the employer thinks there should be a 2, is there any formal way of settling that, Wayne?
Yep, you go into the award, and it's under classifications, and it basically spells out what the expectations are for each of those classifications. So, as I said, if they require intense supervision, which is what normally somebody would in the first 1 to 12 months, for the first 6 months it's level 1, then it moves to 2. Basically, if there's somebody that's been with you for 12 months and they've got the hang of the business, and you don't need to have them riding shotgun with you. You can basically tell them to go and do X, Y, Z in the paddock and then report back to you. That'd be a 3. And then the 5, of course, is basically your senior farmhand that either has control over people or basically you have a toolbox meeting, if that's what you want to call them. Once a week, once a month, we're going to do this for the month of June, July, and you set them on their way. That'd definitely be a farmhand 5.
Just got something else just popped in. Hang on, let me get rid of that one. Why do we need to be aware what do we need to be aware of when paying wages super for children who are 14 plus?
Okay, I had this one last Friday. In New South Wales, if we're talking New South Wales, there is no age restriction at all. However, there are a few restrictions around about when they can work. So school holidays is fine. They can do, they're only allowed to do 1 shift. You can't split shifts. They can do up to 8 hours off the top of my head. I'd have to double check that. If it's a family enterprise, so if it's your own kids, nothing happens. They cannot work during school hours, and they can only work up till 9 p.m. on a school night. And they've got to have 12 hours between breaks. So that's for farming in New South Wales. Queensland's got a lot more restrictions, and Victoria even worse still. You need to go and look up the in New South Wales, it falls under the guardianship, and it also falls under Industrial Relations Commission. In Queensland, it's the Queensland Government of Education from memory. And I think they've also got their own little thing as well. So yeah, I've got a client who just basically wants it's a son of a worker. He's 12 years old, and he's going to just do front of house in hospitality, just direct them to the tables, give them a glass of water, etc., stuff like that.
And Wayne, just on that, then any special rules around super, or does normal super still apply? Thinking back a long time ago, there was that $450 a week or a month. limit
they
that
have to
super
work
didn't
they have
apply?
to work 30 hours now. I think it is from that. Yeah, I've sort of taken my eye off the ball, but there are rules around that. Yeah, but I'm pretty well sure it's 30 hours. I'll have to look at that one, take it on notice. I'll send you an email on that one. So
Okay, thanks. Yep. For annualised salaries on the Hort Award, is it appropriate to state the number of hours over 38 hours a week that are considered reasonable hours?
yeah, yeah. So just quickly on annualised salaries, and we can thank our lawyers for that. So in the law industry, a first year lawyer normally gets somewhere in the vicinity of $60,000 to $90,000, which doesn't sound too bad. Unfortunately, in a lot of places, it's a written rule that you better be in the door before the principal gets there, and you never go home before the principal leaves. So, if the principal's got a lot of work on, or maybe having a blue at home with wifey or hubby, depends these days. The lawyers, male and female. So it was found that some lawyers were doing, 65, 70, 80 hours a week. There's even a famous precedent where a lawyer had, she was a female lawyer, she actually had her assistant lying in bed with her at the motel, still doing stuff at 11 o'clock at night. So what they found is that whilst these lawyers might have been on their $80,000, $90,000 an hour, when you have a look at the outer limit of hours, they weren't even making the minimum wage. So for an annual, they brought in a rule, annualised salary. You've got to work out the outer limit hours. So most of them based on a 50-hour week is 2,552 hours. So that's 48 weeks at 48 weeks at 50 hours, and then the 4 weeks annual leave at 38. Works out about 1,500 or 2,552. If you go over that, so what you have to do there is you have to do a reconciliation. Most people, for whatever reason, seem to want to do it around about the 1st of April, when it's the time when they're doing their fringe benefits and that. And it's just a simple calculation. These days, most people use electronic platforms. So you just put in the amount of hours they've done for the year, divide that back by what you paid them. If they're haven't met the minimum rate, you've got to pay them the back pay. If it's all moved on and sweet and fine, you can do that. The reason I think they use the 1st of April is they're just checking it ready in preparation. They've got to get all their bookwork out to do their fringe benefit stuff, and they also know that there's going to be another wage increase in from the first full pay period of July. So they want to capture it before people have moved over into the next financial year, and they don't cop the extra money, which is the same principle for annual leave. There's a lot of people at the moment suddenly realising that people have got in excess of 8 weeks annual leave. They're probably on $35 an hour when they incurred the annual leave, but now they've moved to $45 an hour. We all know you've got to pay the annual leave on the current rate. So from an accounting point of view, you've put money away for annual leave at X amount of dollars, but when it comes time to pay it, you're out by $10 an hour, times that by 38, times that by 4 weeks. If they suddenly decide to take 6, 8, 10, 12, the record at the moment I've got is I'm doing one 17. They've got 17 weeks of annual leave. So in your award, anybody over 8 weeks, you can speak to them. You can make them use up as much annual leave right back to 6 weeks. You can't make them take it any sooner than 2 months from the day you tell them, and you can't extend it out past 12 months. Likewise, some people. Yes, Mike. Yeah.
Just going back to that annualised salary. So,
yes.
Without having to do all that, like I'm employing someone as a farmhand. I'm saying I'm going to pay you 120,000 a year. The old statement around being on a salary was, well, you're being paid to do the job no matter what hours it takes. does that still apply, or is there an expectation that even if you're on your salary, you shouldn't be doing more than 60 hours a week or whatever the number might be?
Again, it comes back to reasonable hours. So if you're paying somebody $120,000 for a year, and just say that the minimum rate is $40 an hour for a farmhand level 5, so long as you're over the $40, you're sweet. There's not a problem at all. Reasonable overtime is considered. Again, as I said, anything I tell you today, work health and safety trumps that. So, you certainly wouldn't, even if they are your senior person, you wouldn't want to be seen to be working you into the ground, because I'm telling you now, if they have hit a tree or a lot of questions around meal breaks and that. Lot of people don't know, but they all of a sudden become type 1 or type 2 diabetes or diabetic. You don't know when that's going to occur. And trust me, work cover are coming for you. If they can prove that, you worked them excess hours or you didn't afford them their meal breaks or something like that, you're going to be in all sorts of hurt. So, yeah, those days are gone, Michael, unfortunately. So 120,000 seems good, but if it turns out that they're doing 80 or 90 hours a week and you times that by 52, times, work out what they would have been on for the first 38 hours, remembering everything after that is then overtime, public holidays, etc., annual leave, holiday loading, 120,000 might not be the norm these days. It might be 135, it might be 140. It's you just can't say, well, here's 120, away you go. You got to be able to prove, you got to be able to show somebody if they come knocking on your door that this is what you based your 120,000 on.
So on that, if I've got a salaried employee, I should still be asking to, well, either I should be keeping or they should be keeping some sort of timesheet, should that?
Everybody, and yet again, and luckily we're moving into the electronic age, and I've actually converted a lot of my clients onto some electronic platforms. The law says, the Fair Work Act says that you cannot pay somebody unless they provide you with an accurate, up-to-date, unaltered timesheet. So, everybody, managers and that down, and I've had many a blue of many managers on some pretty big properties, but it's quite easy. Just go onto the Fair Work Ombudsman's webpage and show them. It's no different to the meal break. So once again, while we're talking about timesheets, one of my pet projects is they must record that they have taken their meal break, no less than 30 minutes, no longer than an hour, because after hour 5 and 6, if you're in agreement with each other, any hour after hour 6 becomes double time until they afforded a break. Again, that's all part of work health and safety, but it's also under the Fair Work Act. There is another one of your members that I dealt with probably 4 or 5 weeks ago now, and that involves a backpacker. She hasn't recorded, or she hasn't recorded their meal breaks. So I've said to the employer, well, after 6 hours, you should have been paying double time. She's given a figure. I said, how about you meet that figure at 50, start low, start at 50%, see if they're happy to accept that offer. If they're happy to accept that offer, I'll do up a deed for you so they can't take it any further and you just pay it. So, yep, everybody, all your managers, I know your managers will jump up and down and say, I basically run the operation for you. You've got to have a timesheet to pay them. So that's where, and if you have difficulty with people, I forgot my timesheet, I left it in the header, or I left it in the tractor, or I left it at home, well, don't pay them. Don't pay them till they provide it to you. However, if you're one of these companies that pays fortnightly and they give it to you 2 days after payday, you do actually have to pay them, as painful as it is. So pick your battles there. You can't wait till the next pay cycle. They are entitled to it. And as I said, that would be classed as an underpayment of wages, jailable offence, criminal offence these days. So to be honest with you, the Fair Work laws streamed a lot more towards the employee than the employer than ever before. You're right to disconnect, okay? Your employees don't have to respond to phone calls. go and answer anything till the next day they're rostered on, unless you're going to pay for them, or unless you're paying them, as in your example, Michael, with your senior person on the 120,000. It's the expectation that they do reasonable things. The fertiliser deliveries, which was due to come at 6 o'clock, now not coming till 9 o'clock because they've had to come through flood waters or a breakdown or whatever. They just can't leave the fertiliser bloke sitting there, so they'd have to go down. So two choices: was that part of their package to do that, or are you going to pay them for the half hour, whatever it took to do it? Whatever seems to be the best on behalf of the employees is the way the commission would look at it. So
I think so. We're almost out of time, but a few little questions and issues in the chat. One of them was whether the concessional superannuation contributions are going up for the 26-27 year, and just doing a Google search, yes, the answer to that is going up to 32,500, up from the 30,000 current. Wayne, do you have any sort of suggested tools for the timesheets? A couple of people have come in and said Deputy is easy and syncs with Xero. Someone else has put Farm Simple in. Are you aware of any others?
The Fair Work Ombudsman has some templates on timesheets and actually has their recommended timesheet. Now, whether you convert that across to electronic, I'm not really sure. But the Fair Work Ombudsman does have those templates. Remembering that the Fair Work Ombudsman and the Fair Work Commission are two totally different bodies. You won't get anything out of the Commission. They're the judge. They're the court. You just can't walk and speak to the judge. The Ombudsman is there to help you. So, yeah.
Very good. And yeah, someone just wanted to check in. Can you confirm the level of annual leave? You said employees shouldn't have banked beyond, or when you can step in and get them to start taking. What level was that?
Under the partial, after 8 weeks. You can't leave them with any less than 6, but yeah, you can start asking them when they reach to 8 weeks. Can't make them take it any sooner. So you come to an agreement. You can't make them take it any sooner than 2 months. So you allow them time to prepare, and it also helps you prepare. And you can't extend it out past 12 months. If they refuse your request, you just issue them a demand letter saying that we consider you on annual leave as of the 27th of July 2026. See you in 3, 4, 5 weeks' time. Remembering they can cash up to 2 weeks annual leave, no more than 2 weeks though.
Thanks, Wayne. And look, we are at time, so really appreciate your input, Wayne, and thanks for everyone. And certainly, as mentioned at the start, if you've got any further questions or topics that you'd like on webinars, please drop them into the chat. And also just be aware that as levy-paying members of Cotton Australia, you're entitled to up to 2 15-minute free consultations with Wayne if you've got any IR matters, and his contact details are on our website underneath the Workforce tab. So, yeah, much appreciated, and thanks everyone for coming on and giving up your time. Hope you found it useful. Thank you.
Thanks for listening. Thanks, Michael.
Thanks, Wayne. No, it's been fantastic.
Yep, beautiful. All right.
All right. We'll no doubt do it again at some stage in the not too distant future.
There's rules changing all the time here. So
yeah. Yes, no, absolutely.
It's a struggle to keep up with them some days, but anyway, that's what happens. So